Hey y'all, we're back, y'all. We back. Okay, right, y'all. I found some entertainment that we need to catch up on. We've been so busy catching up with our other court appearances. So today we're gonna play catch up with the Tyler Robinson case, the young man accused of killing Charlie. I did find a new security footage that I would like to share with y'all today. And welcome to Let's Talk Choices TV. Yeah. And if you haven't subscribed to the channel, please do. And your membership, get that membership, y'all. Get that membership. I got many more entertainment for you all, educational purposes, criticism. And what I'm gonna try not to do in this video is to do my reaction. I would do my reaction lastly. So I want to welcome y'all here and back. And we back, y'all. We back. I told y'all I had to take a break for a minute to go another direction to work, and then I'll be back here. But we are here in court with Tyler. So just in case you missed out like I did, but we have other things to do. So y'all come on in. I don't want to start the video without y'all, but I'm going to go on to get started though. But I'm back. I told y'all I was coming back. I'm coming back. This is for us and for you all. All right, y'all. I'm going to go ahead on and get started with this video because I don't want to be too late. I'm already at 2 minutes and 10 seconds. Okay? Hope y'all enjoy the video. If you already seen it, don't be kind to others who haven't seen it like me, okay? I'm playing catch up, y'all. I be doing other things. Okay, here we go, y'all.
Calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Bernander, Ryan McBride, Lauren Hunt, Surgeon State, County Attorney Jeff Gray, and Chris Ballard are also present.
Good afternoon.
Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser for Mr. Robinson, who's present in the courtroom, Your Honor.
Good afternoon. Mr. Robinson, good afternoon. And also for the record, the court recognizes the presence of the victim representative, Ms. Erica Kirk. Good afternoon. First, with respect to courtroom protocol to maintain security and decorum, any individual who exits the courtroom during the proceedings will not be permitted to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid inadvertent capture of privileged or private questions by recording equipment or by those present in the courtroom. And as you note, the microphones on your tables are turned off, so please come to the lectrum for making it when you're addressing the court. Second, the court will address the camera and still photographer, camera operator and still photographer. And if you both could come forward, please, to the lectrum.
If y'all can hear, put a 1 in the chat, someone, because I want to make sure y'all hear this. Okay.
All right. Could you both state your names?
John Wilson, KSL Television.
Tess Crowley, Deseret News.
Good afternoon.
If you can hear, put a 1 in the
Could you
chat
state
for
your
me.
roles
Okay.
for today's hearing?
Video recording and streaming of the proceedings.
I'm the pool still photographer.
All right. And have you both reviewed the court's standing decorum order?
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Do you require
Thank you,
additional time
baby.
to
Thank
review
you
the
so
order or
much.
to adjust
Hey,
equipment
y'all.
to ensure compliance? Do you anticipate any difficulties complying with the order?
No.
Thank you both for your cooperation. As we begin this afternoon, the court wishes to acknowledge the importance of safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public.
Hey,
The court
man.
is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone in the courtroom may be addressed by the court. For those individuals who are authorized to have a cell phone, please place your device on silent at this time so that these proceedings may continue without interruption. The court also expects that every person in attendance will be treated with the dignity and respect to which they are entitled to. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during their hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause, and with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately, so each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. And with that, I wish to inquire of a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First, turning to the state, and if you wouldn't mind coming forward, Mr. Gernander.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Falmina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Gernander. For defense.
Good afternoon, Your Honor.
Good afternoon.
Michael Bird for Mr. Robinson. Judge, we have two remaining witnesses. Miss Oliver from the ATF and Miss Carner, also from the ATF.
All right, and to both parties, thank you, I appreciate that. Do both parties anticipate any issues concluding their case? Obviously, there's variables, cross-examination, and the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.?
Not from the state, Judge. Just want to highlight one issue for the court because it may be that the court wants to do some time management. The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. it may be that the court wants to look at the proposed redactions, not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state so the state could raise any concerns about the accuracy of the transcript, that's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So to use court time for the court to look at the proposed redactions may be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday. But it's going to come up today. So the question will be, when does the court want to engage in the process of reviewing a 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up, Mr. Gernander. Do you wish to be heard?
Yes, Tim. The state has received the proposed redactions, and we are prepared to address them when that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
All right. Well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you. All right. Does either party require the benefit of the record before we begin? To the state.
Ryan McBride for the state, Your Honor. Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence, except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles, really, at this stage. One is a gatekeeper role on admissibility, and the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding. And Rule 104A means the court can consider evidence even though its admissibility has not yet been determined in its gatekeeper role. And then, after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant in a preliminary hearing where foundational evidence is reliable hearsay under 1102b3. Even at trial, the State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held the rules of evidence do not apply to evidence used to establish a foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers, when acting in its fact-finding role, only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper, even though the judge as a gatekeeper considers potentially inadmissible evidence. It also means that the court doesn't have to distinguish which hat it's wearing as we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool, and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the presence of the jury. Under the rules, there's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law, and that's conforms with 104B. That's our intention, unless the court or counsel moves to close the hearing. So in summary, the court can and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
All right. Well, I'll hear from defense if you want to be heard on that issue. I see you. Okay.
Briefly, Your Honor, I'm sorry I have 2 microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I'll say.
All right. All right, to both parties, the standing request remains. When you are moving a piece of evidence into to the record, I ask 3 steps. Admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those 3 issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further? All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness. Yes, I mean, I want the press to be able to see it too, but when there is a bit of a distortion when it's at that particular angle. So while the parties are moving forward, go ahead and adjust it, and let's put a sample image of something that has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. And I don't know if we can take a break to make sure that
Is it not projecting on the monitors? Okay. Technology is challenging us again.
Mm-hmm.
Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on? All right, all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind turning off your monitor and then turning it back on, And if I could borrow somebody to do that to the witness monitor as well, so we all get them in sync. Thank you, sir. I appreciate that. And for the lectrum as well, let's just see if we can get that up, because that could cause a delay. I just want to knock this out first. Yes. Where would that TV go? If that doesn't address any
Can't see your
issues,
chat.
then
Can't
let's
see
do
the
that.
chat.
I just want to make it easy. That way that TV can be more flat and it's not a distorted view, and then the media can look at that TV. Again, transparency needs to be viewable, not just there in concept. All right, yeah, let's go ahead and do that. How are the monitors looking? Nothing? All right. I see. Could I have someone with your laptop plug in so we can test, so we can check if it's receiving the data or the information from your laptop to allow us to project? That may be the issue.
Mr. Ellis is plugged in.
All right. Let's take a look here.
Y'all, I can't even see y'all chat, see the chat, and I hit one button and I
Appreciate
can't
the
see
parties'
nobody.
Patience, especially after I just said we're at the halfway point.
We're getting a thumbs up.
All right, so it's displaying for defense, for prosecution. Working on it right now, Judge. All right, and on the screen monitor here, it looks like something came up. All right, and all right, we'll just hope that the monitor for the witness works as well. All right, so we're ready to go.
Y'all, if y'all text something, I don't know what's going on with YouTube, but if y'all text something in the chat, I can't see it. So kind of control stuff for me.
Well, let's go ahead and proceed, and then when we take a break, then we can do that. But for now, media, if you can see that TV, if you have any problems, please let me know. And we're going to bring in that second TV. We just want to get the train on the track here. All right, Ms. Hunt.
The state calls Agent Brian Davis.
Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Agent, if you wouldn't mind having a seat. To your left is a water bottle, and after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice and will have a good record. All right, Ms. Hunt, your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
A total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So, Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with the Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did.
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the city of Utah, local, state, county, all go through to become a certified peace.
I want to talk about a bit about your training experience within law enforcement. What roles have you had at SBI?
I began as a call enforcement team. We did covert and overt operations. I was assigned to an ATF PSN task force focusing on violent felons with guns and drugs. I was on a...
Chad, can y'all hear? Can y'all hear?
Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals.
Put a 2 if you can hear. I want to make sure.
Task force.
Somebody put a 2 if you can hear.
Several different OICI protocol teams, Officer of War Critical Incident teams around the state of Utah and within SBI. I've been on dozens of those scenes.
Put a 2, y'all, if you can hear it, man.
I've been worked a variety of cases. I've worked anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white collar crime, fraud. I was also on a task force.
Somebody put a 2 if they can hear him.
The corruptions task force as well.
Was that all on the job training, or did you receive specific
Thank you, baby.
training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a Faro certified. It's a 3D Faro scan of crime scenes.
What's a Faro scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. I've been on. I've been certified as a forensic interview in the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI?
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the case as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have 2 case agents on a case?
It can be especially on a large case, yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Warren Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large-scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about what we've... So as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elsholz requesting that I travel to St. George.
Who is Sergeant Elsholz? What agency is Sergeant Elsholz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in, or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant Elsholz, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride and myself, and the two pilots.
And who is Ryan McBride?
With the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents within SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
You mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. How did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also, at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
Yeah, I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Down in St. George, Washington County Sheriff's Office, was Mr. Robinson detained at that time?
Yes, he was.
Was he formally arrested at that time?
Yeah, after all the interviews were completed, when we talked to everybody, he was formally arrested at that time.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, can I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may. You're just gonna do the redacted version.
That may happen a couple more times as we go through exhibits because of agreements and disagreements that we have.
Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview in which Mr. Robinson was seated and waiting.
State moves to admit Exhibit 15.
Ms. Hunt, in the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, redaction of the video, and I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so
Okay.
So we're fine with all three steps as to this exhibit.
All right, does the state wish to review this to make sure that what's queued up comports with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
Oh, that was probably really different.
It has no audio, so we would like to admit and publish it at this time.
All right, State's Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or transmitted electronically.
In Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the last couple of days. I assume that we don't need to start over with that today.
Thank you. I appreciate that. I note the standing objection by defense as previously made. And that objection is overruled and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right. All right, State's Exhibit 15 may be played.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark-colored baseball cap with I believe it's like maybe the Hurdy symbol on it, like a white symbol on front. It's a burgundy short-sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes. I believe they're Converse-style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was, so prior to our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from him at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification, the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famuina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, well, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning, and then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Falmina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, close, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Durfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Durfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement?
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at that was the St. George, well, it was the St. George court office, courthouse there. They met and discussed briefly, kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. It sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Santi?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained.
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
to show you what's been marked for identification as States Exhibit 14.1. Let me know when you see that on your screen.
Okay, I see it.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have him in with Ms. Hunt for the same purpose?
And how do you know that?
I reviewed it in its original. As soon as it came to us, I've seen it prior, so.
And Kimberly, if I can have you slowly scroll down. Sorry, Judge, if I can just have a moment.
You may.
I apologize, Your Honor. I misspoke. It's not 14.1. It's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only. Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict? Is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes. It's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission, States Exhibit 14, into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is the unredacted version. So I want to review it before I make that decision.
If I may approach.
You may. Thank you.
Trying to get situated here. Get documents.
All right, I've had a chance to review State's Exhibit 14 and noting the standing objections by defense concerning 1102's court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about what that about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was found on the computer science building on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ed Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ed Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile, and it was a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented, had been fired. It still had the bullet projectile in the end, still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ed Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. You've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall happening there. I believe that happened later. I'd have to. But it did occur. That was obtained from him.
But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence.
But ultimately, a buccal swab was obtained from Mr. Twiggs?
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
also, is during that interview with FBI at St. George Police Department, they conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned second interview of Mr. Twiggs?
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Pete with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schultz, well now it's Lieutenant L. Schultz, and myself.
We've talked about two interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter of the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the time of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
Yes, that's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
By who?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview?
I was.
Did Mr. Twiggs say that he understood that admonition?
He did. Yep, he is.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first, and if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not. I did mention that defense prepared a transcript of this recorded interview, how the state intended to present it, and how we have given it in discovery to defense is it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just, block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it, that they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to
Vistaprint is where your big ideas become bold apparel, so you can wear and share your brand in custom t-shirts, hats, hoodies, and more.
Regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds. Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court, it's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial. State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans, 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is to quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line. And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into evidence case exhibit 16,
Yes.
and as it relates to publication, what is your request?
So, Judge, we believe, I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits, so we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So your request is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom and the audio is able to be transmitted, just not the video via the camera. Is that my understanding?
Correct, that's the state's position.
All right. And in regards to this exhibit, is in the, as states exhibit 16, is there any portion of that recorded statement that occurred before the 1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
All right, turning to the defense, Mr. Novak.
So I'm going to address first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry. The court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript, excuse me, it's only a 20-page transcript. We have given the state a transcript we prepared ahead of time so that the state could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the state doesn't have any dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 1102 interview. There's no surprise here. There's been all of Monday evening, all of Tuesday, this morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made. This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court, and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 1102. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is. There are also portions of this 1102 where Mr. McBride is basically testifying as to what other exhibits that this court will see say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and group chat. I'm just going to distinguish between the two. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court by the state. There are also portions of this 1102 which are not relevant and really implicate Mr. Twiggs' privacy rights. And I'm not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, I don't want to speculate. But it's not relevant. There are portions of it which are not relevant, and there are portions of it which I think, especially to be broadcast, implicate other privacy interests. So I'm not trying to create complications, and I'm definitely not trying to take the state by surprise, because I went to great lengths to provide the state with a transcript, with a proposed redacted transcript. And in fact, today we prepared to make it easier on the state and actually on Your Honor. Instead of having redactions with big black sections, we highlighted them instead. So if the court wants to look at our proposed redactions, the court can do that without having to compare two documents. The other thing I want to say is that if the court did order ultimately that portions of it would be broadcast in any way, in the courtroom, outside the courtroom, we're not trying to change the state's exhibit from a video with audio to a transcript. The transcript is really being used as a tool to address the inadmissible portions of the video, because there's no way to communicate to the court efficiently which portions of a video we think are not admissible. It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it'll probably take a couple hours at the most. So maybe that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing by Friday afternoon. So I've gone beyond the procedural issues. I've addressed that we think portions of it are not admissible. There's no surprise. We've followed exactly what the court has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing, and I don't want to hear objections about it until we're in the middle of the hearing. The litigation over whether Section 1102 is constitutional under Mr. Robinson's federal due process rights and the other rights that were addressed, that litigation does not mean that we should have brought to the court proposed redactions to an exhibit in a hearing which hasn't started yet, in a hearing in which the state hadn't, until 20 minutes ago, even proffered an exhibit. So I understand that the state wants to avoid the substance by trying to short circuit this with a procedural argument. And Ms. Hunt is a very excellent advocate for her client. But the reason why the state is going to the procedural issue is because because the exhibit contains significant content that is not admissible, even in a preliminary hearing. So I'm going to stop now. But I do want to go back and say that if the court concluded that only Your Honor was going to review this exhibit, and the Archuleta rule would be extended to this exhibit, including that it's not going to be broadcast, then I think that we have a different path toward the efficient resolution of this issue.
All right.
Does that make sense, Your Honor?
I believe I understand what you're saying, so let me respond to you before I go to Ms. Hunt. So going to your first point in regards to this court's position in not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence. Typically, motions in limine are used by either side on anticipated exhibits or that may come into court, and that allows pre-litigation. So I want to clarify that the court statement, like I'm not looking at the exhibits, is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant. We could do it line by line or page by page. I know we have had hearings in this matter where the court has wanted to look at transcripts line by line, word by word. We're prepared to do that. But I'm going to give the court categories without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twiggs is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
I apologize. I don't mean to interrupt you. I
It's
just
fine.
want to categorize it and put it in a box. So what is the exhibit? What objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here, because there are two exhibits that I'm very confident are coming. There are portions which are not relevant. There are portions which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today, in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial. And I heard exactly what the court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had said to us, I'm returning the exhibits, but if any party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that it's probably, for counsel, a suggestion about how future hearings where there are many or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins, so that the court knows these exhibits there are no disputes, these exhibits there are disputes, these are the disputes, and we don't have to waste courtroom time bringing the court up to speed on what those concerns are. It can all be briefed ahead of time, and we're happy to do that.
Thank you. Well, going to the last point, let me be clear on the record that I don't intend to interfere with the duties of either party. It's not my job to say, well, here's what you should do, here's what you shouldn't do.
Right.
I'm independent. I'm not team prosecution, team defense. And so I will not dictate how you run your case. Obviously, if it goes against certain rules, constitutional rights, statutes, case law, I will weigh in, but I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do. I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client to the state what is in the best interest of your client. I stay clear of that, but I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management, and now I think we're moving pretty far away from the admissibility of this 1102 statement, and we could have a conversation later if the court wants to. It's up to the court about case management issues. But as I said before, if I say anything else, I'm going to be repeating myself, so I'm just going to stop.
All right, thank you, Mr. Novak. Appreciate your thoughts. Ms. Hunt.
Yes, thank you, Judge. And as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. It was not accompanied by any objections that he actually had. So we had to compare the transcripts and, to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be, and obviously he's now given categories. But I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing, and then probably, I don't know, I'm assuming the media attorneys will want to weigh into that, because I do want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing, and hear from the media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're not for the public in real time, and they're not for the public subsequently. It is very standard that sidebar proceedings where information is only to be exchanged between counsel for the parties and the court are conducted at sidebar so that witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings conclude or the court conducts some closure analysis on a topic by topic basis. So that's what sidebars are about, whether it's done in a closed hearing or in an open hearing through whisper. The public, potential witnesses, jurors, potential jurors don't get to hear what the court decides needs to be addressed in a manner which protects the parties' rights.
All right.
Your Honor, if I may, Michael Judd, on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview that is at issue here is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing, there may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video, the public hasn't seen this video, it seems to me that this appears likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those? Right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks. Because this is so important. So this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is that it should be shown on the screen and that the public should be allowed to see it as well.
Right.
To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then something like the state has provided, which is we would put it We allow the audio to play. If there is some sort of, it sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure, or keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible, and if there is any sort of narrowing of the public's right of access here, that it be done only in the narrowest way possible, and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. I think that important. We recognize that its importance, we take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire, we can handle those counter interests. And on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you. Any further comment by any of the parties? All right. Mr. Novak.
Only that I want to make an additional assertion about why the court should handle this exhibit pursuant to Archuleta. But I want to make that argument a sidebar, because the whole point is to protect my client's right to a fair trial. And by making part of this argument in open court, it's a self-defeating exercise. So when the court resolves whether it will hear from us at sidebar, we're prepared to do that.
All right. The issue is sidebar is public because the transcript's open. So it's just because the parties request sidebar and the court invokes the white noise, that doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing. So
then we would like to have a very brief closed hearing to lodge another objection about the publication of this, of any portion of this exhibit, of certain portions of this exhibit beyond Your Honor's eyes. That's what I'm saying.
Thank you. All right. Right now what we're going to go ahead and do, and what I want to do is I want to look at the redactions that you're proposing. And take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially for future exhibits. So that's going to give us our 15 minutes. I want to review that so I can be brought up to speed because the transcript, from what I understand, is just a transcript with suggestions of what defense wants to redact. Is that correct?
That's correct, Your Honor. And so what I would suggest, well, if this works for the court, is we will email to the court staff something we've already given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the proposed defense redactions. And Mr. Ellis can make sure that your court staff receive that, and it can either be emailed to you or printed out, whatever works.
Any objections, Ms. Hunt, for the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break, and then we're going to come back on the record. But on the break, I'm trying to maximize the time, and that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting. I just want to bring myself up to speed. So on the next step, when I make my ruling, the court is ready to go.
Okay,
and
fair enough.
maximizing the time, because we also want to put up a monitor, so there's like 3 things we can accomplish in the space of 15.
Fair enough. The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, let's go a little bit longer, just I want to make sure everything is in place. Let's come back at 3 o'clock, and we'll proceed from there. Court is in a brief
Okay,
recess.
what I want to do is today is to show you all the video, and what we need to talk about is housekeeping rules when we have the trial, since we are back, since we all are back, you know, up to date with our cases, because I've been covering the other cases that we have been covering. But so let's look at the new security footage with Mr. Tyler Robinson and what's going on. So they showing it to us, so let's watch it, y'all. And I want to thank y'all for being here, and I hope y'all hear the same, you know, welcome the ones who haven't been with us covering this case. But we appreciate you all being here. Make sure, if you haven't subscribed to the channel and been a member to the channel, please subscribe and like the video, okay? Thank y'all so much.
Before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the low-C building. Is that correct?
Yes.
I believe you also testified that you began by working your way, and this is what I remember you saying, so correct me if I'm wrong, but you in essence testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
Correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
We had a known when the shooting occurred, and as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
Did you
yes.
actually see from at least in part where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
You testified yesterday that in reference, I believe, to what's Mark Stacy.
Thank you, Lucky.
That you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same attempt, that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess.
Yes, on each occasion we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor what you're going to see is a paused or a still image. And I'm going to ask if you recognize what you see that now, Agent?
I do, yes.
Okay. Do you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear to be State's Exhibit 12.4?
It does, yes.
So I'm going to go ahead and I'm going to have this video run. And then if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio, is that right?
No, there's no audio on the cameras.
Okay. Let's go ahead and start the video. Your Honor, it's just not up on the screen yet.
Let's go ahead and put it on all screens. No, I appreciate it. Is so it is admitted and may be published to the screens. And just want to make sure it's on your screen, Agent. All right. Mr. Sturgill.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red t-shirt and the shorts and shoes.
And do you believe you recognize who that person is?
Yes.
Who is that?
I believe that is Tyler Robinson.
All right, where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I previously referred it to.
So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then, I'm sorry.
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
And from there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Let me know when you've had a chance to look at that, would you? Were you able to refresh your memory as far as the time?
I was, yes.
And what time was it?
It was just prior to 11 a.m. when he walked off campus.
Okay. And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus.
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why? Well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have.
Ooh, he kind of looking.
From my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
Limp.
Okay. Now what do we see?
This is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, were you able to track Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive. As you can see on the video here, there's a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has a noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct. He would be the rear of the two individuals in this particular video.
So right now, if you were to break this picture into quadrants, where would he be?
He would be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
And what time is this?
It's just afternoon, about 12:15.
On what day?
On September 10th, 2025.
What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner above the building, crouching down and then crawling to the corner of the building.
And this is at what time?
Around 12:23. The timestamp on the video is 12:22.
On the 10th.
On September 10th, yes, 2025.
We're clear, this is the roof of the low-C building.
Correct.
Can you still see that individual?
Yes, you can, Lake Pro.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. The individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building. The almost top center of the image.
What are we seeing now?
Mr. Robinson lowering and jumping off of the roof of the low-C building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching
Campus Drive.
And again, broken into quadrants. Where is he currently?
In the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. The vehicle is driven by Mr. Robinson.
And on the screen, where is that vehicle that you're referring to located if you broke it into quadrants?
It's on the left side, on the upper side, the upper quadrant.
Now what do we see?
And that vehicle's now pulling away and heading east on 800 South.
And why do you believe that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail.
And do you know who that officer is?
Officer Goforth.
Okay. And do you know which department he works for?
Spanish Fork Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
And at what time was that interaction? I'm sorry, did I ask you that?
It was approximately 12:30 a.m.
On the 11th?
On September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, or during the early morning hours of the 11th?
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that, I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle. And then subsequently, when information was available that vehicle, or a vehicle matching the description of that, was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, when you say that, he ran information?
Yes, he ran a partial plate.
A license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes.
And did he tell you who the owner of that vehicle was?
He
actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
Was there any other video that was collected either on the 10th or the 11th that you believe might be important or relevant to today's hearing?
There was a large amount of video.
Well, I'm going to be a little bit more specific. Was there, other than UVU surveillance video, was there any other video that you collected and subsequently gathered an 1102 statement for?
Yes, we collected Ring doorbell footage from the surrounding neighborhoods.
Okay. Let me ask you this. Did that include video from a residence that's located at 680 West, 925 South Warren?
Yes, that's in the Horseshoe area. Yep.
Okay. That's in Orem?
Correct.
And close to campus?
It is, yes.
Okay. And what can you tell us about that video?
There was a Ring doorbell video that was provided that showed a vehicle consistent with the one we had identified as belonging to Mr. Robinson, parking in front of the residence across the street.
Okay. And what can you tell us about the timing and the timing of that parked vehicle?
If I recall, that vehicle parked approximately 0:38 hours on the morning of the 11th.
Okay. So 0:38 hours, what time is that to regular people?
Just after midnight.
At 12:38 a.m.?
In the morning, yes.
Okay. So how did this video come to your attention that you're talking about, this doorbell or whatever?
This footage was obtained as part of the canvass of the area that was conducted as part of the investigation.
Were you able to identify the owners of that residence?
Yes.
Where that video was collected from?
Correct.
Okay. And do you know who it was collected from and by whom?
It was Mr. and Mrs. Noble. I believe Agent Davis collected the video directly from them.
Okay. And do you know what date it was collected?
If I can refresh from my notes.
If referring to your notes will refresh your memory, go ahead and look at that. Don't read it out loud.
I don't have the specific date, but I do know that myself and Agent Davis returned to the address as we had done with previous videos, and had the owners of the video verify that it was from their system. And we did have them complete an 1102 statement, which would be dated.
Okay. Do you know? So let's talk about this. What does this video look like?
It's a nighttime view looking from the front porch of the residence across the street.
Okay. And what about that video? Why was this particular video significant to you, or why do you think it was related to this case?
We know from the UVU footage that the person we believe to be Mr. Robinson had an interaction with law enforcement, and a short period after that, the vehicle comes to that house, and some additional evidence that was collected from cell phone data and things indicated that Mr. Robinson was in the area, and we were able to locate the footage of his vehicle on that Ring doorbell camera.
Or at least what you believe is his vehicle.
Yeah, the vehicle we believe to belong to Mr. Robinson, yes.
And is there something about this particular video and this I guess vehicle that was captured that leads you to believe that it was Mr. Robinson's vehicle?
Yeah, the vehicle has very distinct wheels. I won't say that they're wholly unique, but in terms of the video footage that we were reviewing, the wheels on the vehicle are fairly unique and stand out on the video footage.
So again, this is video that you received early on in the investigation.
Yes.
And then in preparation for the preliminary hearing, you went back out and you met with someone about this video.
Correct.
Who specifically did you meet with about this video?
Met with Mrs. Noble.
And what did you do with Miss Noble?
We did what we had done before. We had a specific file that we wanted her, or files that we wanted her to verify. The footage itself is broken into, I believe, 10-second segments. So we had specific files that we had her view and confirm that they were actually from her system. Those were written on the 1102 as they have been before.
Okay, and who wrote those file names on this particular statement?
I believe it would be my handwriting on the 1102.
All right. What did you do next?
We had view the videos and then complete a statement verifying the authenticity of those videos on the 1102.
Okay. Was this also prepared on a State Bureau form?
I believe this was on a State Bureau Investigations form, yes.
And in this particular form on which Ms. Noble presented her statement, does it have the advisory that it would be used in lieu of her testimony here today?
It does, yes.
Does it also contain a warning that if she gave a false statement, she would be punished, or it's punishable by a Class A misdemeanor?
Correct.
Okay. I'm going to have displayed on your monitor what's been marked State's Exhibit number 13. For identification, let me know when you see that, would you?
I can see that.
Okay. I'm going to have my assistant scroll through that slowly. Do you recognize that?
I do, yes.
What is that?
The 1102 that myself and Agent Davis collected from Ms. Noble.
And does it appear to be in the same condition as when you collected it?
It does, yes.
This is a copy, right?
Yes.
Okay. And the personal identifying information appears to be redacted, is that right?
That has been redacted, yes.
Okay. It wasn't redacted when you collected it, right?
No, the original form was not redacted.
So other than the redactions, it appears to be in the same condition as it was when you collected it?
That is correct.
The state would move to admit Exhibit 13. Agent Holt, do you recall when you collected this written statement from Ms. Noble?
Yes, it was in April.
In April, do you know what day?
April 6th, I believe.
Okay. And you collected it, did you go to her home? I think is that what you said?
Yes, myself and Agent Davis went to the residence.
Okay. And did you sit there while she prepared it?
I did, yes.
And did you witness her sign it?
I did, yes.
Okay. At this point, I move to admit Exhibit 13.
Again, following the same formats, have it on that first portion of the screen for about 10 seconds, and then scroll down to the written portion for about 15 seconds, and then scroll to the very bottom to ensure that the full exhibit has been displayed. All right, that concludes the publication of State's Exhibit 13.
Thank you, Judge. The video that you took with you that day when you visited with Noble, or Miss Noble, had you previously, well, you've stated that the videos that you showed the Nobles were actually more than one video.
Correct.
Okay, and I believe you said they were like 10-second clips.
If I recall correctly.
Short clips. And you showed Miss Noble all of those videos that are identified in that statement.
The one shown on the statement was shown to Ms. Noble, yes.
Okay. Have you had a chance to review what's been marked State's Exhibit number 12.2?
Yes.
Okay. And when did you have a chance to review that exhibit?
I believe that was reviewed last week, I believe.
Okay.
With yourself.
Okay. And does that video, is it a single video that you watched?
No, I believe it's 4 separate short videos.
Okay. And as far as, and I understand that, but as far as 12.2 is concerned, what does that exhibit consist of?
It shows the vehicle believed to be driven by Mr. Robinson arriving in front of the residence, an individual exiting the vehicle and moving away from it, followed by an individual returning to the vehicle and unlocking it. And then it shows the vehicle a short time later starting and leaving the area.
And those are the videos that you showed Miss Noble?
Yes.
Okay. What I have displayed on your monitor was Ben Mark's plaintiff's or state's exhibit 12.2 for identification. Let me know as soon as you see should be a still image.
It's there.
Do you recognize what's depicted there?
Yeah, this is the view looking what would essentially be west across the street from the Noble's residence.
Okay. At 12:38 a.m. I guess, or 0:38.
Yes.
Okay. And what is depicted in this? I think you've already described that. So, Judge, I would move to admit Exhibit 12.2. Agent Hull, this particular video, you've described taking several videos to Miss Noble and having her review them.
Yes.
Okay. This particular Exhibit 12.2, have you watched it in its entirety?
Yes.
Does it consist of either some or all of those videos that you showed Miss Noble?
It does, yes.
And is it a single video? Is it a compilation, that is to say, or is it 4 different videos?
It would
or a number of different videos?
be a number of short videos sequenced.
Okay. A number of short videos in sequence?
I believe that's how this one plays, yes.
Okay. Just again, I seek to admit it.
Anything further from the parties? All right. All right. Given my previous rulings on exhibits, I applied the same analysis and find that State's Exhibit 12.2, I believe, is admitted over the objection. It may be published in the courtroom and by the media, if so chosen.
Okay, so before we play this video, again, what is it that leads you to believe that this is Mr. Robinson's vehicle?
The shape of the vehicle can be clearly seen as it pulls up, and the distinctive wheels on the vehicle also.
And well, let's go ahead and play it.
Is there any sound associated with this?
There is, Judge, but it's night sounds. It's crickets chirping. And,
Okay, I just wanted to see if
What's
there
that?
was. I just wanted to see if there was sound or not. Okay. All right, you may play the video.
so in the first part of that video, what do you see?
The vehicle we believe to be driven by Mr. Robinson pulling up and parking in front of across the street, but in front of the residence.
Okay. And then in the next video, what do you believe is displayed in that video?
There's an individual who gets out of the vehicle. You can hear the door close, and then that individual moves away from the front of the vehicle. There's actually 2 reflective panels on a dumpster, and you can see the individual pass those reflective panels.
And the last of those series of videos?
last one, the individual comes back across those reflective panels to the vehicle, unlocks the vehicle and gets into it. And then in the last video, the vehicle is started and individual drives away.
Agent Hull, I asked you earlier, after you had testified about all the video that you've watched, and video that you believe depicts Mr. Robinson from the UV surveillance, and that combined with the driver's license and the DMV records, whether or not you believe that that person that you have seen in the video and on the driver's license record is in the courtroom today. And I believe your answer was yes.
Yes, that's correct.
And then I asked you if you wouldn't mind pointing him out and describing something that he's wearing. And I don't believe that I allowed you to do that.
Okay.
Would you do that right now?
For the purposes of this hearing, I find that Agent Hull has identified Mr. Robinson. Again, this is only for the preliminary hearing.
All right, y'all. That is information there is for the preliminary hearing. And we will be on time when they start this trial. I told y'all I'll be back, and I'm not going nowhere. So I'm going to definitely need mods in the chat for me during the time of the trial. I want to thank you all for watching. And I caught up. I'm all caught up. I feel good. Okay, and I love y'all. You don't have to love me back if you don't want to, but make sure you like, share, and subscribe to the channel, and also get your membership. Thank you for the donation. Thank you for all participants, and welcome back, y'all. We back. I love y'all. I'm out of here.